Morning all. It's been a few weeks since we've done one of these, or I've done one of these, so it's nice to be back in the saddle. But I think everybody got bored with webinars for a while. This one though is pretty important right now going forward with the next phase, with everybody coming back to work. I know we've been spending a lot of time internally around it. I'm really interested to see what Nick's hearing and dealing with it on a day-to-day basis to be able to work through, because it is the new challenges, working out how things are going to work out going forward. So some of the things we're going to run through today on the agenda are a couple of sort of practical issues and a few more sort of, I think Nick's going to give us a feel around how things are actually developing. So working through workplace, return to work, the workers' WH&S issues, how we're going to work through redundancy and restructure and redeployment. And then there's obviously a moving issue at the moment with casual employees. The government's proposing all sorts of things to change how those rights change, potentially limiting casual sort of relationships up to a year. But that's all moving around until the government makes a determination. So before we get to Nick providing us with all the valuable stuff, I'm just going to give you a quick sort of synopsis of some of the things that are where we're coming from and how it's been developing, mainly through a few articles and a few comments that we've had from our clients. So we'll just dive into that. So the big announcement a couple of weeks ago was 14 December, the public health order, which sort of suggested everybody should work from home, is repealed. So effectively the government saying, righto, get back to try and get back to work. Obviously the 14th of December is not exactly a prime time for work now. It's probably, I think a lot of people are looking at it and saying, well, it's too close to Christmas. We're looking at it on our basis to sort of try it on a soft basis and see how we can work things in and consider that, and then work on those issues through sort of January. Once everything comes back up in late January, we'll have a bit more experience with that. So the stagger of staff, I think everybody's still coming in on public, driving in. There's a lot more traffic on the road than there was a couple of months ago. So public transport numbers are probably still small, but obviously everybody's getting a bit more comfortable that there's a limited amount of COVID rolling around at the moment, subject to any outbreaks in the next few days. So everybody's getting more comfortable with that approach. But next Monday, it's somewhat back to normal in a post-COVID world. Some of the articles that have been coming through and people making their own statements around it are really around individual sort of preferences, I think, and there are some sort of background issues that are coming through. If you look at a couple of the articles we have on the next page, mostly the peoples who are rebelling, and there is some rebellion, and we have it in our business, is the people who don't want to commute as far as they used to. So the ones who are an hour and a half, 2 hours out of Sydney, rather than commuting 4 or 5 days a week, they would rather do that on a limited basis. And everybody's having to deal with that and work through that. It may well be that this is a trend that will develop going forward. And I'd like to hear what Nick's view is on whether that means that everybody's going to have a change in their contract, or whether that'll be part of the terms, is how many days in the office you get and whether you actually get paid more or less or in between around those things. And then there's also the working from home issue about isolation, how that all works in terms of mental health, that layering over the top of some people saying, well, I'm really relaxed at home and I can have a greater lifestyle, with other people saying, well, no, I need them in the office because I need to deal with it. Layering on top of that, the fact is that some people are saying that they're working harder because they're spending more time on emails because they just have to spend more time. It just takes longer to get things done. So, and then there's the issues that have sort of erupted this week in the next batch of articles, which is the ATO getting an action from its union around bringing people back to the office. This actually happened during COVID, and there's a misleading claim there around whether they actually disclosed properly. And that will be interesting to see how that plays out, because that will set some sort of position on what needs to be disclosed and how people need to work through it. And then we have all of these vested groups, particularly the property council, right? That they're obviously wanting to get everybody back into the CBD because it helps a lot of their members. and they're pushing for the government to try and push all of that and everybody back in as soon as possible, obviously in a safe way, and trying to work through how that works with the separation you now need to have, or at least for the moment, until we get to a vaccine in sort of March maybe, and see how that plays out. So in summary, there's obviously a number of differing views here. There's a short-term management of the office and in the home cycles. There's also how those working from home agreements will bed in the future, and how that'll be dealt with, and whether that'll impact packages. And then there's also the longer term sort of implications. Is there going to be more job sharing or 4-day weeks? And are, like professional services and other businesses, go to hub and spoke models where they might have an office, it might be closer to home or whatever else. And then there are other issues erupting still in the background here, like the workplace war that's going on between the union and the government on the casual employees, like I've mentioned, and part-time permanent after 12 months, and that could change the economy materially. And then there's all of these other underpayment issues. G8 came out last week and said, oh yeah, we might have missed a few people. 80 million's a fair whack. And I think there's probably more of that to come, and that's a developing area as well that we're starting to see. So on that, I'll just put that on a kicking tee and leave that for Nick to give us the real answers.
Thanks, Todd. The timing of today's presentation is opportune and unintentional, on the basis that we scheduled this probably 3 or 4 weeks ago, but it just so happens that this omnibus bill landed in Parliament yesterday, which is the result of these IR working groups that were started when COVID hit. And you can already see the union versus government rhetoric that's going on in relation to some of these pretty critical issues that the government are looking to legislate on. And to be honest, it's probably the most material IR change since work choices, which was 06, and then the Fair Work Act came in 09. It's been pretty stagnant since then. This is a bit of a game changer. I don't expect the world to change on Monday because that New South Wales public health order has been repealed. Certainly there are some significant implications because of its repeal, but given we're in this enormous state of flux about both what's happening with COVID, a vaccine, IR change, the Fair Work Commission has significant changes, I think during the course of the first couple of quarters of next year, we'll actually start to see a little bit more concrete in terms of what the government's doing, what employers are doing. But on that basis, I'll get into the content. There's quite a bit to go through, and I don't propose to cover all of the topics in detail, but the slides will be available after the recording, and they do include quite a bit of content. So these are the topics that we're going to cover. Some things that I won't cover, just in the interest of time. JobKeeper's been done to death. Obviously, you can rely on HLB to talk you through eligibility and payment rules. What I'm going to look at is these flexibility provisions that are quite unique. Return to work, work health and safety, redundancy, casual employees. Just with these workplace flexibility provisions under JobKeeper. So as I mentioned, I'm not focusing on the payment rules and eligibility. This is JobKeeper 2.0 and some of the powers that are enshrined in the legislation to give employers flexibility to make changes to their workplace arrangements because of COVID. Now, you can only understand how these provisions were enacted if you understand where they came from. And it's because of this provision in the Fair Work Act, which is very inflexible, not specific to the pandemic at all. And one of those arcane provisions that's been in the IR legislation for a long time that most employers really struggled with when COVID hit. This basically says that an employer in very limited circumstances can stand down staff, meaning they don't have to pay them. And it only operated if there was a stoppage of work And if that stoppage was for a cause for which the employer was not reasonably responsible. Employers were battling with that when it came in. There was a lot of confusion as to whether it applied to the pandemic, and it certainly didn't apply across the board. It was really a case by case based on the direct impact of the pandemic on your particular business. So that's where these JobKeeper flexibility provisions came from. It recognised the fact that stand down provision was confined, and it only really helped employers that were, to be honest, shut down or unable to operate, not those employers that were still operating but materially impacted. Yes, there's been some cases since then. There's a Qantas case, well publicised, that has given some guidance on that provision, but then we've got JobKeeper, and now we're in 2.0. So 2.0 at present, running until March 21. The flexibility provisions I will come to. What 2.0 has done, though, is create two categories of employers who can access these flexibility provisions. What are the flexibility provisions? So these are, in short, provisions which give companies and employers the ability to either issue what are known as stand down directions. That can be complete stand down, i.e. not working at all, or telling staff to work less hours, or alternatively directions about working different duties or different locations, i.e. at home, for example. As I said at the outset, 9 December, yesterday, we got some new legislation. Part of that legislation sought to extend some of these flexibility provisions. So the legislation is literally just landed. It will be debated ad nauseum, but there is at least an intention on the part of the government to extend some of these flexibility powers. So that's a watch this space. So two types of employers, two categories. Your qualifying employers are your employers that are still receiving the subsidy. Generally, you've got your 30% decline in turnover test for most businesses, charities 15. There are other rules which we know about. You're a qualifying employer if you're still participating. You've still got qualifying employees and you're still receiving the wage subsidy. So those employers still have these powers to give what are known as JobKeeper enabling directions dealing with the categories that I talked about: standing down staff, alternative duties, alternative locations. The more interesting category are your legacy employers. So these are employers that are no longer eligible. So were participating, did have participating staff, but from 28 September are not participating. Now those organisations become categorised as legacy employers if they satisfy this reduced decline in turnover test, which is a 10% test. And you also need a certificate from a financial services provider to certify that that decline has happened. And yes, there are rules and conditionality attached to all of that, which I won't get into, but at a high level, 10% decline in turnover test. And if you do satisfy that test in respect of to particular quarters and periods that are specified in that slide, it will then give you powers to make these JobKeeper directions or agreements for the specified period that is in the table. The significance of these JobKeeper directions are that they will override whatever is in the employee's contract, or if they're subject to an award or enterprise agreement, it can be replaced. So very powerful, which means you can really get around some of the inflexibility that lives in particularly the modern awards. Accrual and service means while an employee is stood down or receiving one of these directions, they still accrue leave as if the direction had not been given. So if you've got a full-timer that you're directing to work a day a week, they are still accruing leave on the basis that they're working full-time. And the period of the JobKeeper direction counts as service. There is a dispute section of the Fair Work Commission devoted to disputes about these JobKeeper directions, and there have been plenty, majority of which run by individuals unrepresented, wanting some clarity about whether the direction was reasonable or not. So lots of case law already. And and pretty accessible for employees. And very importantly, these directions will only be lawful if certain procedural requirements are satisfied. So you need to issue the direction in writing. It can't be unreasonable, and that's one of those lawyer words that we hate, but the Commission will use that as a basis to test whether it's lawful or not. But importantly, you need to issue notice and consult before issuing the direction, which really means it's a two-stage process, 2 documents. Here is our notice of intention to give you this direction, and we invite you to consult. And once that consultation has happened or has not happened, then you can issue the actual direction. So the specific rules, pretty detailed and complex, and probably need some help getting around them. But unless you do that, the direction's not lawful. Now, the significance of the consultation is it's longer for your legacy employers. You've got to do a 7-day consultation period as opposed to 3 days for your qualifying employers. So the next couple of slides just set out a bit more of the detail for you that you can take away, and explaining the difference between your qualifying and your legacy employers, starting with the JobKeeper enabling stand down direction. For your qualifying employers, that can be a complete direction. So directing employees not to work any hours at all. Whereas with your legacy employers, they can't be reduced to less than 60% of their ordinary hours pre the direction. And longer, as I mentioned, longer notice and consultation. The other directions, so directions about working different duties and locations, I've got some conditions attached to those in the slide. So there's a safety condition. If it's about duties, they need to be within the employee's skill and competency. They've got to be licensed. You know, if someone's working in an office and you're directing them to drive a forklift, they've got to have a license, things of that nature. But otherwise, legacy and qualifying employers retain pretty much the same powers, but for this extended consultation obligation for your legacy employers. There, at the bottom there were powers to issue directions for employees to take annual leave for JobKeeper employers. They are now repealed, but that power still exists subject to the legislation and the modern award that your employees are covered by, which I can briefly cover. This omnibus legislation that landed yesterday, there's a lot in it, but relevant to today, and one of the contentious provisions that is being proposed is this idea that you can agree with your part-time employees to work extra hours without incurring overtime rates. Unions are obviously up in arms about it, but that is what is being proposed. Short notice, I need you to work an extra few hours this week. Employee can agree, even by text message, informal means. No penalty rates with respect to that, or overtime rates, I should say, with respect to that additional work. None of this is in yet, though. I must emphasise that. This is just being proposed. Alternatives to stand down, I'll briefly touch on what I've talked about with respect to Section 524, the original stand down provision, now the JobKeeper flexibility provisions. They're only applicable to those eligible categories. Alternatives to stand down, simply important to mention because stand down is contentious and it's risky. You're dealing with legal powers that live in the Act that are very confined to particular circumstances, and you could get it wrong. There's already been lots of claims. When I'm talking about alternatives to stand down, really I'm looking at reaching agreements with staff. I talked about fairness and employee buy-in. Agreement lowers risk. You can always agree to vary an employment contract, and that can be with respect to some of these areas. So as opposed to a stand down, reaching a written agreement for an employee to take leave without pay, which is a different category, but has the same effect really at law. Annual leave, long service leave, obviously covered by the legislation. There are powers in the Fair Work Act to direct non-award employees to take annual leave if it's a reasonable direction. So things like an annual shutdown would be considered reasonable. The modern awards, though, is the caveat. If you've got award covered employees, you need to check what rules live in the modern award about those powers. And reduction in remuneration and reduction in days work, all of these things can be done by agreement. I think there will be a lot of claims next year against companies that have simply directed their staff to have a pay cut or work less hours without really having proper agreement. You're not seeing a lot of those now, but people start losing jobs next year. JobKeeper finishes. I wouldn't be surprised if some of these disputes come into play. So moving to the interesting topic of the day, which is return to work. What is work? People are clearly working from home, but when we're talking about return to work, we're really talking about the usual business premises of the employer. That might be an office, it might be a factory, it might be a warehouse, it might be another location. But as Todd mentioned at the outset, this public health order is about to be repealed, and it has essentially mandated that employers cannot require staff to come into the office, and I use office as the example, if it's reasonably practical for them to work from home. Now, that has caused a lot of organisations issues. Look, for many organisations, working from home has operated entirely efficiently. I don't think working from home is going anywhere. There's a lot of rhetoric from the government about let's get our staff back into the office from Monday, but the Fair Work Commission is almost adopting a contrary view and saying, look, we need to embrace flexibility. We are looking at all of these significant changes to workplace instruments to accommodate more flexibility. So I think you need to be cynical about, the government rhetoric versus what might actually happen, which is really empowered with the Fair Work Commission. So I mentioned the Work Health and Safety Act. No matter where your staff are working, it is a workplace. So you've got duties to ensure a safe workplace, which I'll come back to. Stand up really is not a legal term, but where so many employees are stood down, there will be a tendency now when business conditions improve for employers to wish to stand those employees back up. So that could be lifting one of these JobKeeper directions. Obviously, the lawyer in me will say, do all of that in writing, explain the basis, consult with your staff. Directions about employees to come back into the office. It's interesting that the Fair Work Ombudsman now is hurriedly updating their pages to address this sort of scenario. And I think you will see genuine disputes here where organisations are from Monday and leading into Christmas, maybe less so, but certainly at the start of next year, asking staff to come back into the office. They're not prohibited from doing that. The Ombudsman is saying, as long as that direction is reasonable, it is lawful. And that is an age-old employment law concept that basically means you can issue a lawful and reasonable direction as an employer. And if your staff don't comply with it, it can be misconduct and may give you a basis to terminate. But again, there's that lawyer word, reasonable. What's reasonable? So you'll have, I expect, disputes about, Todd mentioned, public transport. I think safety will be the primary bit of, leverage that employees might utilise to try and resist a direction to come back to work. The Ombudsman uses examples of, the hairdresser that directs staff to come back into the office, but they don't adequately social distance, they don't have proper equipment, they're not using masks. That might be a reasonable circumstance where an employee could say, no, I'm not coming in. And that might be held to be reasonable. Clearly, employees with underlying health conditions might have to be put into a different category. The point is there's no hard and fast rules here. The public health order ending means that, yes, you can direct employees to return to work if it's reasonable, but there still needs to be a case-by-case consideration. And the work health and safety legislation is imposing a whole separate layer of really compliance in that you need to ensure that you've got a safe workplace. There's a lot of good resources online. The Ombudsman page will direct you to pages where you can complete your COVID safe plan, where you can register as a COVID safe business, even if you don't have to, if you're not a restaurant or a bar. It's pretty easy to do. Like, for example, we did it with our office. It's basically a checklist that covers things like hygiene and distancing and dealing with outbreaks. It doesn't take long to complete, and then you can register. And really, it just shows as a business that you've turned your mind to safety. Obviously, vaccination will probably be the next big worldwide dispute, as if we haven't had enough of them in the last 12 months. But, you know, it's pretty amazing that sitting here in December, we're looking at people being vaccinated in the UK. I didn't expect that to happen so quickly. There's not really any government directives or even indications about how they intend to roll out a vaccine in Australia, but I fully expect that to be contentious. There is a growing cohort of the population that are cynical about a vaccine, and I think that's only going to continue. There was an article that I got sent from the Law Society that was dealing with whether or not it was lawful to direct, lawyers to have a vaccination. And obviously you're dealing with 10 or 12 different lawyers that had an opinion and none of them agree with each other, which is unsurprising. But there's clearly, again, no hard and fast rule. And while case numbers in Australia are dropping significantly, I think it will be difficult on the face of it for organisations to mandate that employees have a COVID vaccination. In the same way that they can't mandate that people have a flu vaccination. I don't know. Again, it's a watch this space, but the case law authorities on what's a lawful and reasonable direction, I don't think necessarily favour at this point a COVID vaccination being mandated by employers, in the same way that when they introduced this COVID Safe app, which we probably all downloaded and then forgot about, they had to legislate to say you can't require your staff to download it. Yeah, you can suggest that it might be a good idea, but you can't require it. So probably the next big worldwide dispute, sadly, but that's the way it is. Just dealing with WHS and working from home. Working from home, as I said, despite some of the government rhetoric and the repeal of the public health law, I don't have any doubt that it's here to stay. There has already been a lot of movement in the Fair Work Commission, and with modern awards and some of these industrial instruments during the course of COVID being amended at record speed, like what usually takes 4 years has happened in 2 months with respect to changing significantly some of these awards. They're really looking at incorporating flexibility, however defined, into some of these industrial instruments. So when JobKeeper finishes and some of these other flexibility provisions, which really give powers to employers, disappear, I wouldn't be surprised if we were looking at a modern awards system that looks quite different to what it looks like now. Australia has an incredibly complex, overly complex modern awards system. We've got over 100 awards that apply to different organisations based on what the employees do or the industry in which the employer works. It's incredibly complex. Even as a lawyer, it's incredibly complex. We have one of the most complex IR systems in the world. I think COVID has probably proven that it is too complex and we probably need to simplify it. How we get there is probably a 4-year job, but clearly the Commission is alive to the fact that they can't have these very rigid regimes in awards that don't provide for flexibility. I've mentioned the Clark's Award by way of example. Obviously that has wide application in the Australian economy, people doing administrative and clerical work. They have this Schedule I, which is now extended until the end of March. And it's a good example of what the Commission is looking at, which is permitting employees to work from home, to work outside the usual spread of hours by agreement. Agreements about taking annual leave at half pay, twice the amount of leave at half pay. I think this stuff is here to stay. All of the stats suggest that, and these are probably a bit illusory at the moment because of the impact of COVID and people not physically coming into the office or being allowed to, but every time you pick up a paper, you'll see an article about working from home. I just don't expect us to suddenly go back to a 100% working at the employer's premises environment. I think it would be high risk for organisations to adopt that view.
Nick, just a quick one. Do you think that complexity of the award system is that part of the underpayment issues we're seeing? That people, it's so hard to be able to process and understand.
Absolutely. So underpayment is a whole different topic, and part of these omnibus bill changes is to federalise, wage theft as a serious contravention, and it's happening in some other states. But this underpayment area has been on the radar of the Fair Work Ombudsman for a few years now. Like pre-COVID, everyone was excited about it. They changed the modern awards with effect from March, ironically, to introduce or modernise some of these annualised salary clauses. But prior to that, you remember you had all these high-profile casualties, a lot of the hospitality targets in the paper that were underpaying staff. Woolworths was in the paper underpaying staff. And yes, it's because the modern award system is incredibly complex. Like I have a client that I work with, they've got employees subject to a particular award. If you are trying to strictly comply with the annualised salary provision of the award, it is incredibly difficult and onerous for record keeping purposes and other purposes. And this is basically giving companies the ability, instead of paying award rates, to pay a flat salary that's over and above award rates, that's meant to fully compensate people for all of their work. But the compliance to achieve that in the award system is almost impossible. So my view is they need to fix it. And yes, I don't expect this wage theft stuff to go away, but unless they improve and simplify the awards, like bring the number of awards down is my view. Like some jurisdictions will have 2 or 3 or 4 awards. There's got to be a better way. And look, this won't be a quick fix, but I think COVID is just like, let's get through COVID. But I think there's an emphasis now on the need to simplify the IR system.
Because if you look at it, I mean, we deal with it when we go in there. You've got an overlay of EBAs, and then you've got awards, and then you've got specific pieces like long service leave, which is variable in each state and whatever else it is. Like you can spend months dealing with it.
Look, I guess it keeps me in a job at the moment. So, hey, let's keep it complex. No, but it is crazy. And if you're a small business, like it's so tough being an employer. More tough now. Like I've got friends that run a restaurant, and them trying to stay across, forget the awards, stay across the New South Wales government changes that are affecting hospitality that are announced, then subject to these public health orders that are basically really complex bits of legislation that you can't locate or interpret. They've got no idea. Ring me every 2 days. What does this mean? You jump on the New South Wales government website, they'll have a press release, no real detail, and they're expected to comply strictly. They've got licensing police knocking on the door. You're not complying. We are incredibly regulated, and I think it needs to improve. Anyway, that's my rant. But on working from home, these are not what I've put in this slide. These aren't requirements. I guess it's guidance on the basis that if employees are working from home, it's a workplace. A workplace is wherever your staff are working, whether that's in the car or at home or in the office. And that means you've got 2 bits of legislation that are underpinning what your obligations are. One is workers' comp legislation. So if your employees are injured and it's a workplace and it's because of work, then you'll have a workers' comp claim. In the most extreme example that was a case this year, a husband actually murdered his wife at home, and the children ran a workers' comp claim and were successful on the basis that they held that there was a link to work because she was working excessive hours and remote working, and the organisation hadn't, appropriately divided the line between work at home, which is an extreme and really sad and terrible example, but it emphasises that, the home is work and you as the employer have obligations in respect of it. So safety, equipment's a good one, and I'll come back to it because there's a good case that came out the other day. Psychological health, that's just huge at the moment. That's no surprise to anyone that psychological health can be as significant as physical health and can result in claims in the same way. Most of the claims that I see in my space are psych claims, employees alleging, bullying and isolation, etc. I think next year. We're going to see a lot of those. Look, they have always been around in the context of employees that are being, performance managed or realise that they might be terminated and going off on sick leave, and whether it's valid or not, those claims will always be around. But the isolation and the unique working environment that COVID has caused, I think, will result in some claims. EAPs, a lot of my clients will have and roll out other things, voluntary programs to deal with employee mental health, flexibility around timing of working hours. And again, that is partly constricted by what your awards and your agreements provide, which is, again, subject to this new legislation. I just found this case interesting, and a lot of employers probably breathed a bit of a sigh of relief when they read it. But this was a case, basically an unfair dismissal claim, where the worker resigned because the company wouldn't provide him a desk. And I think it was even a Victorian case, and the commissioner that heard it said they'd provided enough. He had a laptop and an IT setup, and a desk wasn't a requirement for the company to provide. So at the moment there's no legislation about what equipment employers provide. It's an organisation by organisation thing. Most of you listening today will probably have put your hand in your pocket during the course of the year to provide more equipment to your staff than ever before. I know, I can put up my own hand and say we're in that category. And look, it's resulted in efficiencies and improvements for staff, but where is the line drawn? It's blurry. And I include two links here that relate to that. The ECTU, the Union Working From Home Charter, again, it's a charter that they have published, which doesn't necessarily pertain to anything other than their views about what working from home should look like for employees. They're suggesting things like provision of equipment, ensuring, reasonable working hours, division between work hours and home hours, safety. It's probably a starting point for their views on negotiating some of the legislation. And the other link is what the Fair Work Commission president released a few months ago now by way of this award flexibility schedule. So they've basically created this draft schedule that they think the various interest groups should now debate and make submissions on. And it's probably been parked a little bit because of this omnibus bill, but it's interesting because it deals with things like enshrining into awards working from home arrangements, compressed work weeks, so the ability for employees, for example, to work their 38 hours in 4 days instead of 5, annual leave at half pay, purchased leave, agreements to change the span of ordinary hours, agreements to share reductions in working hours across the organisation, directions to work at different workplaces, and staggered start and finish times. So when I said at the opening that there's a bit of a tension between the government's rhetoric that, let's get back to work and get the economy clicking, and the Fair Work Commission, which really makes decisions ultimately about what the awards say, their view is we need to embrace flexibility and find the right balance. I won't spend much time at all on this. I just thought it would be good for your own information, just COVID-specific types of leave. So the awards have unpaid pandemic leave, all of them, which is about self-isolation because of COVID or being stood down because of government or medical authorities. Specific types of employees in high-risk areas have a paid pandemic leave provision, which will expire next year, which deals with the same types of circumstances, but that's more for your info. This is a government payment, so employer doesn't really need to engage with it, but it's just an FYI that some eligible employees that don't have sick leave or they've run out might have an entitlement to this disaster payment. Just moving on, the last couple of topics, I mentioned, we've talked about a lot of positives. There are still trying times ahead for organisations. So redundancy is clearly still on the agenda. I've still got a lot of clients that are looking at downsizing because of COVID. And even though powers like stand down have given employers the ability to put off termination and they can sort of preserve the status quo, the reality is that they're still accruing leave entitlements. They've still got headcount issues potentially. So redundancy is often inevitable for a lot of these organisations that are struggling. Again, very heavily regulated. There's a genuine redundancy test in the Fair Work Act, and you absolutely need to satisfy if you want to have some protection from an unfair dismissal claim. So you can still be sued if you make someone redundant for an unfair dismissal. But if you tick the 3 boxes really in this genuine redundancy test, you'll go a long way to putting yourself in a position to defend that claim. The tricky ones in the genuine redundancy test are about consultation. All of the awards have a consultation provision. You must consult with staff before making a final redundancy decision, and you must give them information in writing. It's all spelled out in detail in the awards. You have to do that before redundancy, or it's not going to be a genuine one. The other component is about redeployment. You must consider redeployment, and if it's not reasonable to redeploy, you'll tick that box. I mentioned GP claims in the second bullet point. The genuine redundancy test is specific to unfair dismissal. Employees may have rights to bring general protections claims. I've seen a lot of them in the last 6 months, which is employees saying, I think the redundancy is contrived. I think the real reason that you are removing me is because I'm the one that's on workers' compensation, or I'm the one that has previously made complaints about you or my manager. It's just another avenue. So what I'm saying to clients is, in concert with your lawyers, so a lot of this stuff is privileged, get a business case document together about why you are making redundancies. It can end up being a pretty handy document to rely upon if you end up in a claim, because a lot of these claims are about what was the motivation of the decision maker. And really, the decision makers get cross-examined in court about why they chose a particular person. And if you've got a contemporaneous document you've created now that says we are restructuring because of the following reasons, you're not including anything unlawful like, yeah, we're picking this person because she's pregnant or because this guy's on workers' comp. It can be a pretty handy document. And you can work with your lawyers to get it right under privilege. It doesn't have to be a document that's widely distributed. So that's a bit of a tip for redundancies. And obviously your small business employers get an exemption from redundancy pay obligations. There is also a basis in the Fair Work Act to make an application to the Commission to reduce redundancy pay if you cannot pay the amount. So there's been a few of those cases, unsurprisingly, in COVID, but you still need to make that application. You still need to prove to the Commission that you cannot pay the amount, and you probably have to open up your books and records to substantiate that. To finish on casual employees, again, it's been very contentious in the last 12 months, primarily because of a couple of cases that have attracted a lot of attention, and I'll deal with them in a second. But when COVID hit and these IR working groups are put together by Christian Porter, one of the areas that they were looking at was casual employment. They were working with the unions and other groups. Because of these cases, when this omnibus bill landed yesterday, the unions were unsurprisingly up in arms about what the government was proposing for a definition of casual employment. And if you look at it, it's really a way for employers to contract in a casual employee, which is essentially the old case law treatment before these new cases threw a bit of a spanner in the works, which is a long-winded way of me saying, if you have in your contract that the employee signs up to be a casual employee and you agree that you don't have a firm advance commitment for future work, the government says, well, if someone accepts that offer, they become a casual employee. And that applies irrespective of what the actual true substance of the relationship is. Now, I'm not surprised that that is being opposed, and I would be very surprised if that's what we end up with. And look, I'm not surprised that the government's trying to legislate to create a definition of casual employment, because at the moment there isn't one and we need one. I just don't think it's going to be as self-serving as that. The other thing that I think Todd foreshadowed at the start is they're looking at this casual conversion power, which basically means if you are a casual employee that has been working fairly regular and systematic hours over the course of 12 months, you can make an application with your employer to convert to either part-time or full-time, depending on the hours that you are working. It's not an absolute right to convert, or as far as I know anyway, it's an application to convert, and the employer can then accept or refuse it. And if you refuse it, it's on reasonable business grounds. Now, that casual conversion entitlement already lives in all of the modern awards. So if you've got modern award employees, check your award, there'll be a casual conversion clause in there. So not surprising in that respect. And to be honest, I don't think it's a bad idea, because as soon as you've got a casual employee working for you for longer than 12 months, they get in that high risk category anyway. Your casual staff members are the ones that you're paying a casual loading instead of accruing leave entitlements for them. You are paying them a high rate of pay. These are staff members, if they are working regular and systematic hours, that are in the higher risk category to run a claim that they're actually a full-timer. That's what happened with these cases, the workpack cases. Now, Rosado, the second one, has been appealed all the way to the High Court. And on the 26th of November, High Court granted special leave to appeal, which is basically the first stage before they hear the actual appeal. At the moment, current state of the law is this casual staff member that was a labour hire contractor had a casual employment contract, paid a casual loading, regarded as a casual by workpack, but the true substance of the relationship was that there was 12-month rosters in advance, they were working long-term hours, regular and systematic. So there was a distinction between, what the contract called this person and what they were actually doing. So workpack was unsuccessful. This person was held to be basically a permanent staff member. The consequence of that is annual leave, sick leave, etc., back pay. Even though the casual loading was paid to compensate for these other things that they didn't receive, they were unsuccessful in being able to offset it. That's the other thing that Christian Porter is trying to include in this legislation. If you're a casual staff member and you agree you're a casual staff member, if you subsequently prove that you're a permanent, then we can offset the casual loading that we've paid you. Again, watch this space, because it's going to be very contentious. But the High Court will hear this next year. That's probably going to change what the legislation ultimately looks like. And if the government doesn't like the result of the High Court case, if workpack loses, they will try and legislate around it. So again, watch this space. That's pretty much all I've got. I think we've got time for some questions. In the what's next, look, disputes about working from home and JobKeeper, underpayment and other claims next year from employees. Like as I said, a lot of staff that have agreed, whether in writing or not, or sort of being forced to work less hours or have a pay cut. We might be looking at some claims next year. The IR reform is a big one. It's going to happen over the course of the first couple of quarters of next year. And didn't even talk about gig economy and independent contractors, like casual employment. No real statutory definitions. Lots of bad news stories at the moment with gig workers, Deliveroo, Uber, etc. Not having workers' comp, people being killed on the road. It's going to be a real push, I think, to try and legislate there. I might finish up there.
All right. Well, I might start firing some questions.
Right.
First one's from Meredith, who's been very patient. They're using shifts in their office register and desk booking system.
Yeah.
Is there anything else you've seen that's more effective or user friendly?
Right. So this is simply around trying to accommodate spacing in the office.
Yeah.
Look, no. For is there a better solution? It's got to be a fit for purpose for your organisation. Like, look, we were in our office doing the same thing. We had a shift system. I can tell you right now, it was an absolute disaster. Only because lawyers don't like having to tell anyone in advance what they're doing, but
it's not just lawyers, mate.
Yeah, because of the nature of the way our business was set up and our size, If people were at their usual desk, they would have been too close. So we had to sort of split the office in two and do shift. Yeah, a bit of a disaster, but we got there. Yeah, no real on market, applications that I'm aware that make that easier. What I would recommend though is jump on the Ombudsman page and go click through to the COVID safe plan section. There's a really good document, and I'll find the name. It's a National COVID-19 Commission Advisory Board document, and it deals with COVID safe planning. That might be helpful for you, just for some alternatives.
And also that registration, so to become a COVID safe business, that might also just provide some clarity and some structure to it.
Yeah, look, the New South Wales Government COVID safe plan document is also good, because it asks you specific questions about how you're managing things like spacing and alternative working hours, things of that nature.
Next one, small business redundancy. So the requirements or to qualify, that's still a headcount issue, isn't it? It's still below 15.
Correct. So you're a small business employer if you're less than 15, but that number includes the person being dismissed, anyone else being dismissed at the same time, and importantly, the employees of any associated entities of the employer. So that's a Corporations Act definition, but that could include, related bodies corporate in a group, or if you've got, significant influence or control over entities, that sort of stuff.
And the other issue with that is obviously sometimes, and we see it in what we do in terms of restructuring and in the insolvency space, headcount reductions from 30 gradually done and then ending up at 14, miraculously ending up at 14 and then doing a structure, and that being queried.
Yeah, agree. Yeah, I've seen it a lot, and even before this new definition, it used to happen under the old legislation. The other thing with small businesses is you can still be sued for unfair dismissal, but your employees need to be with you for 12 months before they have those rights, as opposed to 6 months for other businesses. But once you get to beyond 12 months, you can be sued for unfair dismissal. So even if you don't have to pay redundancy pay, you've still got to satisfy that genuine redundancy defence. The other good tip for a small business is jump online and download the Small Business Fair Dismissal Code, which is basically a tick the box document if you are affecting a termination. And if you hold that up in the proceedings and you can prove that you've complied with it, you can defend the claim. So it's
so you got that along with the financial analysis that shows it's necessary for the business going forward. So that business case
still needs to be a genuine redundancy for tax purposes, which is, the position is now superfluous.
Yep.
And that can be a traditional, we don't need 5 salespeople, we only need 3. Or it could be, this person's duties are still required, but we need to split them amongst existing staff. So there's a lot of sort of tax guidance about what that means.
Don't start talking about tax. Nobody wants to talk about tax.
My accountant always says to me, tax is sexy, but I've never really agreed with him.
We have a number of partners who maintain that tax is sexy. I disagree.
Only accountants that say
it. Where can I find? Catherine's also asking, where's that small business code document? Is that on?
Fair Work Ombudsman, but literally if you type in good old fashioned Google, Small Business Fair Dismissal Code, you'll find a link to it. It's on the Fair Work Ombudsman page, where you can get a PDF or a Word version of it or a link to it.
So the other one I just wanted to ask is around omnibus. It seems like the government's ideology in this is to try to bring more flexibility to maintain the employment levels while the recovery is sort of going on. So it's like a soft restructure sort of tool, rather than, if they didn't bring this through, there'd probably be more hard restructure where there would be more terminations and more exit, and the unemployment would go up. And then it's more difficult to then re-employ and then bring those numbers back up. Is that your feel of what they're trying to do?
Look, the one that was always going to go down like a lead balloon was this, like a work choices agreement, which is the one that's got the most airtime, where they're basically saying employers in particular industries that can demonstrate COVID-related hardship can reach an enterprise agreement with their staff, which doesn't satisfy the boot test. And the boot test basically means the agreement's got to be at least as favourable as the underlying modern award. So unions just see that this is a John Howard work choices agreement. So the old AWAs,
yep,
basically meant you could agree to contract out of the award. So look, that's going to be criticised to the high heavens, and I understand why it is. Look, clearly there's economic rationale for businesses to reach these agreements if their staff are agreeing in a transparent way. To make an enterprise agreement is difficult. You've got to go through a voting process, a disclosure process. The Fair Work Commission has to approve it. Unlike the AWA, which you just signed off on and put in your back pocket, the Fair Work Commission has to approve it. There's a public interest test. So it'd be a pretty high threshold to get that across the line. So it makes economic sense to me. Don't think that's going to end up in the final version of the legislation that we see.
Because the thing I see is that we're obviously going to be involved in a lot of restructures, and working through these issues and having the flexibility they're talking about will actually allow us to rationalise the costs and be able to try and maintain headcount as much as possible, and then stabilise the business and bring it out the other side as parts of the economy recover at different levels and different rates. So it does make sense, but it's just going to add another layer of complexity. So I suspect that you're going to be very busy just with everything that's going to go on with the normal businesses, and then the ones going through restructure needing to adhere with all of these things as well.
And look, what's happened, like the ATO, the regulators in my space have just done nothing during COVID because it was just a bad news story. So you're not hearing about the ombudsman, taking on underpayment and people breaching JobKeeper directions, et cetera, et cetera. But that might come back next year as the economy recovers.
And there's a big chance that this will be involved in due diligence as well, right? There'll be people buying businesses and merging and whatever else and making the thing work, because that's always another issue that sort of arises.
Yeah, agree.
All right, I think that's it. So we're on time. Thanks for everybody. Have a good day.